All right, Crim 1, here we go with Chapter 4, Criminal Law and Defenses. So, that's interesting. Oh, there we go. What is law? We have a rule of law and law. What's written here is well, obviously you can see what's written here. The guiding principle of the U.S. legal system states that no single person is more powerful than the law. Now, some of you are probably reading that, looking at that, saying, is that really true? And I think it's a reasonable question to ask. Is it really true? Does it depend, does justice depend sometimes on the amount of money someone earns or the amount of power someone has? I don't know, maybe. But that's not the way it's supposed to be. But having said that, just looking at the word law. Laws are formal rules of conduct sanctioned by the state. So here in the United States, if something is not written down in a penal code book, in a court case, in something like that, if it is not written, it is not a law. So laws are rules of conduct that are laid out for us so that we all know how to behave in society. The history of criminal laws. Long before recorded history, obviously, as your book says, people didn't have written laws during that time. They clearly they didn't have paper or pencils or anything to write with or on. So what they did at that time was live according to unwritten social norms. So behaviors were just expected, and if you did not behave in a certain way, then you would likely face punishment from society. This code of King Yornam, you see that. That code indicated that capital crimes included murder, rape, and robbery. A capital crime is a crime for which the sentence could include the death penalty. Then we moved on to the first actual written code, and that was the Code of Hammurabi. Their basic principle was the idea that if you committed a crime, the punishment should be at least proportionate to whatever it is, the crime that was committed. So, for example, if someone was murdered, then it was very likely that the amount of punishment that the suspect would receive would be very severe, as opposed to if someone, stole a loaf of bread, the punishment would not be the same as if they committed a murder. So obviously, I'm assuming that makes sense. Mosaic law, that was the principle of an eye for an eye. This is kind of a revenge or vengeful type of law, meaning things like if you beat my sister up, I would get to go and beat your sister up. It was going to be equal. We had an eye for an eye during that time. Ancient Greeks started to rely heavily on written laws, and I'm going to skip the last part. Common law. Common law is an English concept where things are not specific, laws are not specifically written. So if something is considered a common law in the United States, there really is no such thing, because I told you a couple slides ago that if it's not written, it's not law. But it does, so precedent. Previous court decisions that have binding authority on a subsequent case. Of course, the jets are flying over my house at this very moment while I'm trying to record this, but that's okay. Sound of freedom. Okay, so what does that mean, precedent? Think Roe v. Wade, the Supreme Court decision that made it such that abortion was legal in all 50 states. Well, what happened in maybe 2023, the Supreme Court reassessed Roe v. Wade and decided that the states should decide and should have the power to decide whether or not abortion is legal in each of these states. So when the Supreme Court made that decision, the law changed because there was a change in the precedent. So the most recent Supreme Court case addressing abortion is no longer Roe v. Wade. It is the subsequent case where the Supreme Court decided that abortion should now be legal as defined by each of the states. So most of our laws also, I want to point out, because it's probably going to be a quiz question, most of our laws are based off of the English legal system. So even though all of our ancestors, or the ones who came from England to the U.S., who hated England so much, left the U.S., or left England, came to the U.S., and then based their entire legal system on England. So anyways, what's next? Civil law. Okay, so we have criminal law, and then we have civil law. So civil law is non-criminal law. Generally speaking, we think about maybe we've been injured. Usually it's injured in some way, and as a result, we are suing whoever we think is responsible for the injuries that we suffered. So just an example. Let's say, and actually this is a true story from a civil attorney friend. Family was driving down the hill from, I think it was Mariposa, something like that. So there was a family of 4 in the car, and they were stopped at a light or a stop sign. I don't know, but they were stopped. And behind them, there was a large cement truck. The large cement truck had some faulty brakes. And as the family of 4 was sitting in their car waiting for the light to change with other cars in front of them, the cement truck plowed into the back of this vehicle, I believe killing one of the children instantly, and then the other child, unfortunately, both of the parents were trying to help the child, and they sadly had to watch their child die in front of them as they were waiting for help to get there. They were up in the foothills, and sometimes it's difficult to get an ambulance or EMS workers up there. So who's responsible? So should someone pay for what happened to that family? So what would happen is the family would be the plaintiffs. They would be the parties who initiate the lawsuit. Either the driver and or the owner of the truck or the cement truck company would probably be the defendants who are being sued. That lawsuit that is filed is called a tort, and damages would be whatever type of amount of money or property, but in this case money, is deemed reasonable by the court for the trucking company or the cement truck company to pay the family. So not generally, in civil court, we are at risk of losing our money, okay, property, money. In criminal court, we are at risk of losing our freedom. All right, so next slide. Is it going to work? Maybe. There we go. Criminal law. Body of laws which are punished by the government for specific prohibited actions. So when we think about criminal law, there is a really thick book, at least in the state of California, called the California Penal Code. In that penal code are a list of every single crime, every single action that is illegal in the state of California. Additionally, there is a punishment that is attached to each one of those crimes. So let's say I committed a misdemeanor battery offense. I slapped somebody. So if I were convicted of that crime, there would have to be some sort of punishment attached to it so that I would, maybe hopefully not do it again. But every law that is written does have a punishment assigned to it as well. Some of those only include things like fines, and others the punishment could go all the way up to death. So double jeopardy. Fifth Amendment protects anyone from being tried twice for the same offense. So I like to use O.J. Simpson in this particular case description. The O.J. Simpson is alleged to have murdered his ex-wife and her friend, Ron Goldman. This happened in the 1990s. And he was tried for that crime, and he was found not guilty. Many people believe that he was guilty, but for whatever reason, he was acquitted or found not guilty of that crime. So let's say today, 30 years later, maybe more than 30 years later, but anyways, 30 years later, O.J. Simpson, who is out and about, has run out of money. And he decides that in order to get money, he's going to do an interview with Oprah Winfrey. And she's going to pay him $100 million. And during that interview, he says, yes, I killed her, and I killed him too, and this is exactly how I did it. Can he be tried for that crime again? And the answer to that question is just absolutely no. Now, if the first time he were tried, there was a hung jury, or the jury couldn't come to a unanimous decision, then he could be tried again. And then restitution in a criminal case is similar to restitution in a civil case, except for it's usually a smaller number. But let's say I smashed someone's car window and I got arrested for it and convicted. Restitution for me would likely be to replace the car window. I'd have to pay for it. So restitution. I do want to go back between civil and criminal law. There's also a different burden of proof for each type of trial. So if you are being tried for a crime where you could actually lose your freedom, the burden of proof or the amount of evidence needed in order to convict you would have to be beyond a reasonable doubt. That's a really, really, really high standard. Okay, going back to civil law, that burden of proof is different. In civil law, the burden of proof is a preponderance of the evidence. So really, it just has to be more likely than not that the person committed whatever act they're being sued for. So going back to O.J. Simpson, I love his case because there's so many interesting legal issues, but O.J. was found not guilty in a criminal court of killing his ex-wife and her friend. However, the families did file a civil lawsuit against him, claiming for wrongful death. That lawsuit was successful, and he was deemed to be responsible. Preponderance of the evidence. The burden of proof was so different in those two cases, and the outcome was completely different. In one case, the civil case, he was deemed to be responsible, and the criminal case, he was not. So, anyways, interesting differences. Felonies, misdemeanors, and infractions. Felonies are typically more serious offenses. You can go to prison for a felony, and the fines can be much more significant for a felony conviction. So more than a year in state prison. Misdemeanors. These are generally considered lower level crimes, not as serious as felonies. You can only go to jail for a misdemeanor, no prison, and the fines are significantly lower. Then we have infractions. Those are usually traffic violations or something very small, something for which you would get a citation or a ticket. And you cannot go into custody for an infraction. Corpus delicti, body of the crime. That's a definition that is a Latin word, corpus delicti, or Latin phrase, and the definition of that is the body of the crime. What I've done here is listed exactly what the California Penal Code says is battery. A battery is any willful and unlawful use of force or violence upon the person of another. So if I'm walking through the classroom and I trip and on my way down, I slap somebody by accident, trying to grab onto the desk so I don't fall on my face. Have I used unlawful force? Have I used force or violence upon another person? Yes. However, all of this has to be true in order for me to be found guilty of a battery. Was it willful? And the answer to that question is no in the scenario that I just gave you. So every crime will have something written like this that'll tell you exactly what needs to be present in order for a person to be convicted of that particular crime. Then we come to intent. Criminal intent, the degree to which a defendant must have intended his or her actions or the consequences of those actions. So intent, going back to that battery that I just described, when I tripped and fell and accidentally hit someone, did I have the intent to hit that person? And the answer is no. Does that always matter? The answer to that is also no, but we're going to get there. Actus rea, again, we're having some Latin terms here. This can be described or defined as the guilty act, the specific act required to convict a person for the crime. Then we have mens rea. Mens rea is the guilty mind. So again, going back to that battery, where I accidentally tripped and hit someone. Did I do the guilty act? Yeah, I hit somebody. Did I have the intent to do it? Did I have the mens rea? No, I didn't. So I'm very likely not going to be charged with that crime. Now, not every offense requires mens rea. Think DUI with injury or great bodily injury or death. These are the strict liability offenses, crimes that require no mens rea. One can be convicted regardless of intent. So I got really drunk and I got in a car and I hit somebody and killed them. Did I mean to go out there? Did I have the intent to kill? Oh, shh. Well, as you can guess, I have a very loud watchdog, so sorry about that. So going back to strict liability offenses, I was talking about DUI. It doesn't matter if you had the intent to kill somebody while you were drinking and driving in that particular offense. So some crimes do require intent and others do not. And usually, again, it's written in the penal code. And then we have inchoate crimes. These are crimes that have been begun but are not complete or are completed by someone else. So what does that mean? Think when someone tries to hire a hitman to kill their spouse or their whatever. If that crime was never actually complete, like the person didn't actually get murdered, that could be an example of an inchoate crime. Okay, next slide. Come on. There we go. Criminal defenses, there are a lot. Mistake of fact. Imagine you happen to carry you have a CCW permit and you are out at the grocery store and you see a man holding a gun to another man's head. And you're like, oh my gosh, I think he's going to kill him. So you pull out your gun and you shoot. After you have shot this person, you realize that, oh shoot, they were making a movie out there and I just didn't know, and they were actors. Mistake of fact. Okay. Intoxication. I just told you something about DUI and intoxication, but this type of intoxication that we're referring to here, these are defenses for criminal court, refers to intoxication that is involuntary. So if someone has roofied me, spiked my drink, forced me to take a certain drug or alcohol or whatever, and then I commit a crime, then I'm not responsible. But if I just go out and start, chugging booze and I get myself drunk, then intoxication is not a criminal defense. Then we have sanity, not guilty by reason of insanity, or guilty but mentally ill. This means that the offender was not sane at the time the offense occurred. So some people in those instances will be found not guilty by reason of insanity. If that happens, they will go to a mental institution until they are sane and then no longer a danger to themselves or others, and then they'll be released into the community because they've been tried already. Guilty but mentally ill, these are people that are generally speaking going to end up in a mental institution or a mental facility for the criminally mentally ill. Justification. When we're talking about duress, that could be an instance where, let's say, someone called me and said, I have your daughter here. If you don't go kill your next door neighbor, I'm going to kill your daughter. Would that always work? And again, none of these criminal defenses are bulletproof. Sometimes they work, sometimes they don't. Necessity. You committed a crime because you were going to starve to death. That would be kind of a necessity type of example. And then entrapment is when the police or law enforcement officials basically entice someone to commit a crime that they probably wouldn't have done if they had not been approached by law enforcement. All right. These are some other defenses. Infancy. I was too young to know better. So that can definitely be a criminal defense. And then consent. I like to use sports as an example for consent. But if you get into a boxing ring, right? What is your expectation? The expectation is that you are consenting to participate in a boxing match. Now, when during a boxing match, are they hitting each other? Yes. Is hitting each other legal? It can be legal if there's consent. So I hope that makes sense. Oh, that's it.